Okay, so hi everyone, let's continue with the third video for week 2 lecture series, and we will discuss partnership obligations and liabilities. So for this part, there are some articles that we have already discussed earlier. So we will just discuss the portions that are applicable to the partnership itself and not to the partners. So the first one would be Article 1818, which we have already discussed. It relates to agents. So here, it says here that every partner is an agent of the partnership, but what we should look at is that the act of every partner, including the execution in the partnership name of an instrument, as long as it's for carrying on of the business, will bind the partnership. The exception, that's why I placed the word unless in purple, is that if the partner has no authority to act for the partnership. And there are two requirements for this exception to apply, aside from the fact that there is no authority, is that the person that this partner is dealing with, meaning the third person, knows that the partner has no authority. Okay, now, in instances where the partner's acts are not for the carrying on of the business, the partnership will still be liable if that partner is so authorized. So for example, in a partnership where A, B, and C are to sell ube pandesal, as long as A, B, and C are partners of this partnership, now each of them can do anything that they want to, as long as it's in relation to the buying and selling of ube pandesal. Now, for people who will be buying from them, whatever orders that they make will bind the partnership as long as it's in the normal way of business. Now, for example, A decides to buy a motorcycle so that they will deliver these orders. It's not in the usual way of business. Therefore, the only time that the partnership is bound is if that partner A in this case is authorized explicitly to buy the motorcycle for the business. Now, the enumeration below, items 1 through 7, are things that can only bind the partnership if all the partners enter into these particular acts. Now, the only time that they will bind the partnership, even if only one, basta less than all the partners enter into whatever contracts these are, is when they are explicitly authorized. So please take note of this. I placed a table which illustrates the enumeration in the previous article that I just flashed. So you might want to use this for reference because it might be difficult to memorize, and I don't suggest that you memorize it anyway since you're not law students. So in this case, as I have mentioned, as long as if the partner is authorized, whether or not that act is in relation to the normal course of business or it's something related to business but not, as what I mentioned a while ago, purchasing of a motorcycle, as long as that person is authorized, it will bind the partnership regardless if the person knows, the third person knows that that partner is authorized or not. Okay. The partnership shall also be liable even if the partner is not authorized, if that act is if the act is carrying on in the usual way of business, so long as the third partner is innocent. Now, there is no partnership liability in all instances if the third person knows that that partner has no authority, and the partnership is also not authorized if the the partnership is not liable if the partner is not authorized, number 1, and 2, the act is not in the carrying on in the usual way of business, regardless if that third person knows of the partner's lack of authority. Now, the second partnership liability would be under 1820. We have also discussed this earlier regarding the admission of a partner concerning partnership affairs. Now, the 2 points that we need to take note under this article is that if it is an admission regarding partnership affairs and it is an admission within the scope of the authority of the partner making that admission, then the partnership is liable. So please take note of these two. That's why I placed them in two different colors. Another one would be under Article 1821. So these three articles are almost one after another. 1821 talks about notice to any partner. Now, this is a case where notice to any partner is notice to the partnership. How would that affect a partnership's liability? Of course, whatever a partner knows, a partnership is presumed to know. Therefore, if the partner knows that the partnership is liable, the partnership has to make good that whatever liability that is. No? So, if you remember in our earlier discussion under the second video of week 2 lecture series, there are three types of notices contemplated in this case. The first one would be notice to any partner as long as the information is about partnership affairs. The next one is notice to the acting partner regarding the matter in which that partner has authority over, whatever it may be. So in this case, a third person notifying an acting partner is notice to the partnership whether that acting partner found out about the information during the partnership or even before he became a partner. If you remember that, the phrase then present to his mind, that will apply to acting partners. And the third scenario is relating to, again, similar to the first one, any partner, so any other partner. Okay, this means partners, not acting partners, who could and should have communicated it to the acting partner. If you remember the second video, the part about when we used the example of real estate, and one of the partners knew that the real estate was subject of a civil case where another person was claiming ownership, that partner who knew about that civil case, even if he or she is not an acting partner, not a managing partner, if they found out about that, that operates as notice to the partnership. So later on, if we're talking about, I'm just repeating the example I mentioned. If the partnership is already staying in that piece of property because they purchased it from another person, and later on they were evicted, meaning the other person, not the one they bought it from, the other person, E in that example, if I remember correctly, was able to gain ownership and had them vacate, then it would bind the partnership. They cannot say, oh, we don't know because A, the partner who found out about it, is not a managing partner or an acting partner. That's not true. As long as that partner could and should communicate it to the acting partner. The fourth partnership liability would be under Article 1796. The partnership shall be responsible to every partner for the accounts he may have disbursed on behalf of the partnership and for the corresponding interest from the time the expenses were made. It shall also answer to each partner for the obligations he may have contracted in good faith in the interest of the partnership business and for risks in consequence of its management. In this instance, there are three cases again. In this instance, 1796, three cases are also contemplated, and I have highlighted them in different colors for easy reference. The first one is for disbursements made by the partner. These are called advances, or in Filipino what you call abono. So in this case, for a partnership to be liable to the partner for the advances or the abonos this partner made, it must be on behalf of the partnership, obviously. And in this case, take note, the partnership is liable, 1, for the amount disbursed or advanced, and number 2, for the interest on that disbursement. Also, we need to note that the liability arises from the time the expenses are made, meaning the partner does not need to make a demand as soon as the partner, say A, already paid, then the partnership is liable. Then that's where interest starts to run. Okay, the second one would be for the obligations it may have contracted in good faith. Now, you would be wondering, what's the difference between disbursements and obligations that a partner contracted in good faith? In the first example, this usually contemplates cases where a partner pays a partnership debt. And the second example, the one in blue, are usually, when you say obligations, these are normally uh, payables or things that must be done in the course of business, say paying of suppliers, when stocks arrive, if it's not on terms, usually it's cash on delivery. Yan. And the third one is risks in the consequence of its management. So for example, in a case where A, B, and C are in the business of, say, Grab, they purchased a number of motorcycles to be used for Grab delivery. Now, the risks in consequence of its management would be, say, if A were hiring people to be their riders for these Grab motorcycles, there is obviously a risk of danger to the riders or danger to the items that they are carrying, assuming that Grab does not have its own insurance. Then the partnership would be liable, even if, say, A ordered these riders to perform the obligations, like to enter into deliveries, no? So even if it were A who managed the business, the partnership cannot deny any payables that might arise from risks in consequence of this Grab business. Now, there's something that we need to note in this article. It says here, if I may go back to number 2 for obligations, it says here, it must be in good faith and in the interest of the partnership business. What do you mean when you say good faith? I'll give an example. In a business where, since the holidays are coming up, if you see on Facebook mga cheese boards, what do you call them? Charcuterie. So these sort of takeaway grazing boards, no? So if the partners A, B, and C were in that business of selling cheese boards or charcuteries, and say they sell it for 2,800, which is how much I normally see it on Facebook. If their agreement was that they would buy their supplies for the cost of 800 pesos only, it would mean that if in the event that they run out of stock and they have customers who are placing their orders because it's the holidays, so it's expected that there will be a sudden inflow of these orders, A, B, or C can at any time purchase the necessary material, supplies, assemble them, and sell it without needing the consent of the other partners. In cases like this, the partnership would be liable even if it were just the act of one, because these are obligations contracted in good faith. Now, for example, A is the managing partner of A, B, and C in the buying and selling of these cheese boards, and they ran out of stock. Their normal supplier is also out of stock because it's the holidays. So A, wanting to make the sale, say some customer says, I want to purchase 50 because I'm giving them away as corporate giveaways. And A is already computing, wow, we would earn, say, how much? 50 times 2,000 would be 100,000. Sayang naman. So A is now scouring for suppliers and finds one for 1,000 pesos. A thinking that, that's not so bad. Instead of earning 2,000 profit because we're selling it for 2,800 and purchasing it from the usual supplier for 800, we would just be earning 1,800. That's still not bad considering that this customer is placing 50 orders of these cheese boxes. Would that still be considered in good faith? And would the partnership still be liable to the supplier if later on the supplier says, hey, A didn't pay me for the 1,000, for the 50,000 pesos worth of supplies. In that case, it can be argued that the partnership is not liable. Why? Because as I've mentioned, A, B, and C agreed we will only purchase supplies worth 800. Now later on, should they decide to go to court, it's possible that they can still argue, it's in good faith if you look at how much I earned for this business. That's a different matter, but at least I'm giving you a simple example of what it means when you say that a partnership is liable for obligations so long as the partner acts in good faith. Okay, the next one would be Article 1822 and Article 1823. If you remember Article 1822, we mentioned this is about wrongful acts or omissions of a partner. So therefore, it contemplates criminal actions or quasi-delicts. Quasi-delicts meaning torts, or acts short of a criminal liability. The instances when the partnership is liable is if the guilty partner is acting in the ordinary course of business or is authorized by his co-partners. Therefore, the partnership will be liable for the loss, injury, and any penalty that may result from this wrongful act or omission. Now, take note, it also relates to omissions. And I will discuss this during synchronous class, an example of an omission. I just have to think of one. 1823, if 1822 talks about criminal liability, 1823 talks about breach of trust. It says here, the partnership is bound to make good the loss where a partner acting within the scope of his authority receives money or property of a third person and misapplies it. And the second instance is when the partnership receives money or property and it's misapplied by a partner. In number one, this is a case where A received the money and A did not account for it, pocketed it, and used it for his or her personal purpose. And number two would be, for example, A as managing partner received the money, placed it in partnership in a safe of the partnership. B goes to the office, gets the money, and uses it for his personal benefit. In this case, note that the partnership's liability is solidary. Oh, before I forget, the one under criminal liability here, this liability is solidary. What does it mean? The partnership cannot say, wait, it's a criminal liability of A, so run after A first. If A's personal property is done, then that's when the partnership will pay. No, that's not the case. In this case, as soon as it is decided that A, the wrongful partner, is liable, then the partnership is equally liable for the same amount. Okay. The third, 1, 2, 3, 4, 5, 6. The seventh instance of a partnership liability is under Article 1825, partnership by estopel. I did not include the entire article because mostly partnership by estopel contemplates liabilities of third persons, which we will discuss right after. I would just like to highlight that there is one instance under Article 1825 when the partnership is liable. And that is a case where a third person represents himself or conducts himself as a partner, if he is not really one, and all the other partners consent to that. For example, A, B, and C formed a partnership to sell cheese boards because they feel that they do not have enough popularity over the internet. They get the endorsement of, say, who's a known celebrity? They get the endorsement of Heart Evangelista, one of my favorites. Now, she, for those of you who do not know her, if she posts on Instagram, hundreds of thousands of people like it. So, A, B, and C go to Heart and say, can you help us, not as an endorser, pretend to be a partner, we'll name you, yeah, we would like to do business with you, so you don't have to invest. Just for this Christmas season. After that, you can stop endorsing us. And Heart says, yeah, sure. So she posts this on Instagram and says, hi guys, I have this business, cheese boards. You may, if you're thinking about the holidays, buy from me. That would be a case of partnership by Estupel, because Heart represented herself as a partner to A, B, and C's partnership when in fact she is not. Now, 1825, as I've mentioned, is different from an instance under 1815 where a partner allows himself or herself to be included in the partnership's firm name. What's the difference? In 1825, this is an act of a third person pretending to be a partner. So it relates to an act or conduct. 1815 only contemplates an instance where the person allows their name to be included. I just want to clarify that in terms of third persons. So we will discuss that. But right before I end this part of partnership liabilities, do know that, of course, partnership is liable for its own contractual obligations. That's why we have Article 1816, which discusses the liabilities of partners separately in case that the partnership's assets are not enough to answer for the partnership's contractual obligations. Okay, now we will discuss 1825 third person's liabilities. This means that when I say third person's liabilities, it's because a third person acts as a partner when in fact he or she is not. See, that's why I have the animation of a bunny, I'm innocent. So, as I've mentioned, it is under Article 1825, Partnership by Estupel. This was included as a provision in the Civil Code because when a person does something, he or she cannot deny. So when a person acts as if he or she is a partner, later on, he or she cannot deny liability because he's really not part of the partnership. So take note that in this instance, a partnership is not created. So in my previous example, A, B, and C talk to Heart about the business. There is no real partnership between A, B, C, and D. The law, that's why there is a need for this article. This is made so that Heart and A, B, and C cannot later deny paying a third person who relied on that representation. There are also examples here where it is not needed that the person relies on this representation and still that third person would still be liable. Let me enumerate these instances. And I'm using the examples under De Leon's book. So for those of you here, you might like to take a screenshot of 1825. I'll give you a minute to read it. Under Article 1825, number 1, a partnership liability results if, as I've mentioned, A, B, and C are the partners in A, B, C, and Co. and company, and they contract, say E, who is not a partner, to form a partnership. In number 1, if A, B, and C consent, and E represents himself as a partner, then this is a partnership, there is a partnership liability, and this is what we call the partnership by Estupel, one of the instances. Number 2, is a case where not everyone consents. Say, A and B allowed E to represent himself as a partner to ABC and Company, then in this case, they would be liable pro rata. So in this case, they are liable pro rata. Number 3, in a case where only E, without the consent of A, B, and C, says, hey, I am part of ABC and Company. I am an unnamed partner. In this case, E has a separate liability, of course, because A, B, and C did not know and did not consent to this representation. This also contemplates situations where there's in fact no partnership. They are just separate individuals who pretend to have a partnership. In any instance, whoever agrees to the representations made by a person will be liable jointly and... Okay, so there is a case here in De Leon that I would like to discuss that mentioned, if I may read it, A is held out with his consent as a partner of B who is in business by himself, and E relied on the representation of B. In that case, the question was, does E, the third person, does he have priority over the property of B's business? Because A held out to be a partner of B and B consented. In that case, A and B would be liable jointly, but only as regards B's personal assets, not the assets of B's business. Okay, so just take note of that also, because that is also part of Article 1825, when a person represents himself or herself to be a partner to someone, regardless if there is actually a real partnership or not. So, and then as I've mentioned just before we started, liabilities of third persons, a third person is also liable if they allow their names to be included in the firm name. Now, as I've mentioned also earlier, there is no need for that third person to act so long as they allow their names to be included. If you look at the provision, those who, not being members of the partnership, include their names. So this presupposes consent. Therefore, if someone, say, I will use for the last time the example of A, B, and C with heart, and they call it ABC and Heart Company. In that case, if Heart did not consent, that did not allow her name to be included, then she will not be liable. There is just one last question. Does a third person have rights similar to that of a partner? If you remember our discussion in the first video, if I'm not mistaken, the answer is yes, but only under Article 1813. Remember, a partner can assign or convey his or her share in the business to a third person without that person being a partner. So in cases like this under 1813, the third person may not interfere with the business, may not assign, or may not ask for the books, except in cases of fraud. So just take note of that, because although we discussed that under partners' rights, it's also partly included in third person's liabilities. Now let's talk about the last topic. Does a third person have rights similar to that of a partner? Technically, they do not have the same rights, but the law recognizes 3 instances where a third party has rights in a partnership. The first one would be under Article 1813. If you remember, a partner can convey their rights or their share in the partnership to someone else. So that someone else, whether it is a purchaser of the partner's interest or an assignee, does not have the right to interfere with the management, does not have the right to ask for information, or nor can they inspect the books, but they are entitled to receive, in accordance with whatever that assignee or buyer and the partner have agreed upon, that third person will be entitled to the profits of the partner, meaning the profits due the partner. Now, another instance would be under Article 1814, if you remember, the charging order, where a judgment creditor, meaning a partner's creditor, adjudged by the court, so declared by the court to be a creditor of the partner, that judgment creditor has the right to get a receiver, not necessarily mandated, meaning they may or they may not. They may also make all other orders, directions, and inquiries that the debtor partner may have. Now, in the third one would be under Article 1831, which we will discuss in week 3 lecture series, would be a judicial dissolution, and we will discuss that. So, just for purposes of enumeration, I have written down these three scenarios where a third person has the rights of a partner. So we have now ended week 2 of our discussion, and I will see you on week 3 when we discuss dissolution, liquidation, and limited partnership. And that would be the last for the law on partnership. See you!